In this video, I'm going to explain exactly what constitutes a legal mistake in contract law. I'll reveal how Florida courts determine when mistakes void contracts and when they don't. I'll also show you two shocking multi-million-dollar cases that will change how you approach every business agreement. By the end, you'll know the three critical strategies that can protect your business from these costly disasters. I'm Santiago Cueto, board-certified international business law expert and best-selling author. And in my nearly 30 years of practice, I've seen how contract mistakes can either completely void an agreement or trap parties in deals they never intended to make. The difference between these outcomes can literally be worth millions of dollars. Now let's start with something that surprises most people. Not every mistake in a contract actually matters legally. Florida law recognizes three distinct types of mistakes, and understanding the difference can save you millions or cost you everything. Now, the first type is called a unilateral mistake, where only one party is wrong about something fundamental. Generally, these don't void contracts in Florida unless the other party knew about the mistake and took advantage of it. Now, if you accidentally offer to sell your office building for, say, $1 million instead of $10 million, and the buyer had no reason to know you made an error, you're usually stuck with that deal. Now, the second type is mutual mistake, where both parties are wrong about the same fundamental fact. This is where Florida law gets interesting, because mutual mistakes can void contracts, but only if they involve what lawyers call a material fact that goes to the very essence of the agreement. The third type is mistake in expression, where the parties agree on the deal, but the written contract doesn't reflect what they actually intended. Florida courts will sometimes reform these contracts to match the true agreement, but proving what the parties really intended can be incredibly difficult and expensive. Now, here's the key principle that governs all mistake cases in Florida. The law generally assumes that competent adults who sign contracts know what they're doing. Courts are reluctant to let people escape from bad deals by claiming they made mistakes unless those mistakes are truly fundamental and both parties share them. Now, let me tell you about a case that perfectly demonstrates how devastating contract mistakes can be. In 2019, a major real estate development company in Miami entered into a joint venture agreement to develop a luxury high-rise project in Brickell worth over $200 million. The contract stated that one investor would contribute $12 million for a 30% stake, but buried in the financial schedules, that same investment was listed as $1.2 million. Now, did you catch that? The decimal point was mistakenly typed in wrong, making the $12 million $1.2 million. Well, when construction began and the dispute erupted, the investor argued he was only obligated to pay the $1.2 million listed in the detailed schedule. The Florida Appellate Court ruled that while the amount seemed irrational, the contract language was clear in the schedules, and there was no evidence that both parties were mistaken about the same fact. The development company had to buy out the investor's 30% stake at fair market value, costing them over $12 million more than budgeted. Now, if you're starting to see why these details matter so much for protecting your business, and you want to make sure you never miss insights that could save you millions in legal disasters, do me a favor and hit that like button right now. And subscribe to my channel so you'll be the first one to know when I break down more of these costly legal lessons. Trust me, the next case is going to show you just how expensive assumptions can be. Now, our second case involves an even larger disaster, if you can believe that, during a corporate merger in Palm Beach, where a technology company was being acquired by a Fortune 500 corporation in a deal valued at $1.8 billion. The acquisition contract included an earnout provision stating that sellers would receive 50% of net profits exceeding $50 million annually for 5 years. Now, after the first year generated $75 million in net profits, the buyers argued this meant 50% of total profits only if they exceeded $50 million, creating massive unexpected tax obligations for the sellers. Now, both sides claimed they understood the language the same way during negotiations, making this a potential mutual mistake, but proving what parties believed during months of complex negotiations became a nightmare. The case consumed 3 years of litigation and cost both sides millions of dollars in legal fees. The Florida court noted that sophisticated parties with extensive legal representation are held to a higher standard when claiming mutual mistake. The case ultimately resulted in a settlement that satisfied no one, demonstrating how ambiguous language in high-stakes deals can destroy value for everyone involved. Based on these cases and countless others I've handled, here are 3 strategies that could protect you from these expensive disasters. First, always include specific calculation examples in complex contracts. This eliminates ambiguity about how calculations actually work. Second, require that all financial terms be stated consistently throughout the entire contract and all attachments. In our Miami development case, the disaster happened because different sections of the contract contained different numbers. Establish a review process that specifically checks for numerical consistency across every document, schedule, and exhibit. Third, include reformation clauses that address what happens when obvious errors are discovered. These clauses can specify that if both parties agree that a term doesn't reflect their actual intent, they can modify the contract without having to prove mutual mistake in court. This gives you an escape valve for genuine errors while maintaining the contract's overall validity. Remember, Florida courts generally won't save you from bad deals, but they will help you sometimes fix genuine mistakes if you can prove both parties were wrong about the same fundamental fact. The reality is that contract mistakes in Florida can either cost you millions or save you from terrible deals, depending on how courts interpret what really happened during your negotiations. Now, the 2 cases we examined today result in over $50 million in combined losses and legal fees, all stemming from language that seemed clear to everyone until it wasn't. As someone who's guided businesses throughout these exact scenarios, I can tell you that prevention is always cheaper than litigation. Clear language, consistent terms, and proper review processes aren't just good practices, they're essential protection. Now, if this breakdown of content mistake law helped you understand how to protect your business from these costly disasters, I'd really appreciate a like on this video. It helps other business owners find this crucial information. And make sure to subscribe to my channel for more insights that can save you serious money and legal headaches. Because when it comes to contracts, what you don't know absolutely can hurt you. See you in the next one.